and we are delighted to have you here with us this evening. If you've been part of our series, this is panel number 3. We are recording it, and at the end of the series, we'll share all 4 panels. Tonight's panel, I'm going to share my screen. Give me a second. I think you can see it now. We are talking about privacy, what that all means for you when it becomes from a digital perspective, what that means for your personal security when you're going through divorce, planning for divorce, or even just in general. How to be safe online and know all those tools, how to keep your documents safe. And we are thrilled today, once again, to have Lisa Zeiderman as our moderator. She is our Savvy Ladies board chair, and she has organized this entire series. So Lisa, thank you so much for organizing it and bringing in such amazing speakers to be part of the panel. I'm going to let you introduce everyone because I know you've worked with most of everyone here and dear friends as well.
All right. Thank you so much, Judy. And thank you all of you for coming tonight and giving us your time in order to talk with these great experts tonight about their expertise. So I'm going to start. Amy Holtzman is a trust and estates attorney. She is actually of counsel to my firm. And in addition to trust and estates, her firm also handles real estate matters. And I go to Amy. She's my go-to for wills and trust and estates and life insurance trusts. And we're going to be talking about all sorts of things, including powers of attorney and revocations of certain documents that you may have signed during your marriage that maybe you're no longer that interested in having. That is Amy. And Nick Himamandez is this unbelievable computer forensic expert. He is president of the NGH Group, and he is an amazing forensic computer expert. I have seen Nick in action, testifying, dealing with my clients, dealing with others' clients, and even when I have an adversary, they always say how incredible Nick is. So Nick and Amy, we're really thrilled to have you. And Robin Badil is executive director of the Debt Capital Markets and Syndicate at ANZ. Robin has gone through her own divorce, and I always find it really helpful to have someone who's gone through the process, who can speak to the process, because it's a hard process, it's a long process sometimes, and it's a stressful process. And I think it's so helpful to hear from someone who's come out on the other side of the process and come out successfully, frankly, on the other side. So we're really excited to have all of you, and we're going to kind of jump right into it and get started. So I'm going to get started with Nick, actually. And Nick, I want to cover 2 areas just globally, and I think they're both interesting areas. I want to cover computer forensics, but I also want to talk about cryptocurrency a little bit tonight. Sure. Because I know that that's an area that you actually delve into. And although it's not on here, it's kind of a surprise, I know, for some that we're going to be talking about it. Right. But exactly, what else is new? But I know you can think on your feet, so I'm not really that concerned about it. So talk to us about exactly what a computer forensic is, and when someone would actually utilize your services as they're going through a divorce action.
Sure. I get that question a lot, like, what is computer forensics? There's all kinds of definitions out there. They're all complicated and technical. In plain, simple English, computer forensics is the digital version of what people think of when they think of forensics, like CSI. What do the forensic people do, like physical forensics, right? They go to a crime scene and they use their forensic skills, forensic techniques, and forensic tools to figure out and obtain the evidence of what happened here, when did it happen, how did it happen, and who did it, right? Computer forensics or digital forensics is basically the same thing in the digital world. We examine computers, computing devices, accounts, and networks, and we examine all the digital artifacts and evidence in those things to determine, for whatever the questions may be that are posed to us, when did something happen? How did it happen? Did it actually happen the way somebody says it happened? And who's responsible for doing it, et cetera.
Okay, now in terms of what you do, so when you're actually, well, let's talk about this. What are the primary privacy precautions that you advise clients to take when they are considering or going through a divorce to basically mitigate the issue of data breach, privacy breach, hacking, intrusion, and I'm going to even say controlling? Because I think that this is a control issue too, that a lot of people find as they're going through a divorce. Somebody has broken into their phone or broken into their computer, is rerouting things in their computer to their own computer. Talk to us about what people can do as a precautionary manner,
Sure.
and how they should prepare for this during their
Sure.
divorce.
It's a huge issue that we deal with. Right. So the computer forensics, like when we're examining evidence for cases, for trial and stuff, we do a lot of that work. But what you're talking about right now probably comes up just as often as that. And whatever the other party's reasons may be, whether it's a need for psychological control, whether it's because they actually want, information to use in the case, or whatever the reasons may be, we see it happen in all kinds of different ways, right? So they could target your phone or your iPad or your computer, right? Target your device, try and compromise your device by installing something on your device. They can, and we've seen much more in recent years of people, estranged spouses, whatever, compromising the other party's accounts more so than the devices.
Mm.
The best things you can do going into a divorce situation or any, high contentious, high risk situation, especially if you're going to have to continue to cohabitate with the other party, right? Um, Number one, you have to change all your passwords. Every single password, not only for all your accounts, but the unlock codes and user logins for every device you have, whether you think or even if, as I hear this all the time, I'm sure my husband or my wife doesn't have the password for that, doesn't know my code for my phone. I don't care how sure you think you are. Change it and change it to something they can't guess. But that's just the very beginning, right? If you did that, but the other spouse is already in your iCloud, well, they can't access your phone or your laptop or your iPad anymore, but they're already in your iCloud. So they can see your texts and get all kinds of other data. You need to go into your iCloud account if you're an Apple user, or your Google account if you're an Android user, and you need to not just change your password for that account, because we see people do that all the time, and the persistent bad actor, estranged spouse, or ex-boyfriend, girlfriend, whatever the case may be, still is in, still is getting the information, and people can't understand why. If they're already in there from some device that you don't recognize, aren't aware of, and didn't notice, you log into your iCloud or your Google account, you change the password, that doesn't automatically kick that device out of the account.
Mhm.
Eventually, when that device gets asked to re-authenticate with the password, then they may not be able to continue to have access. So you have to log into those accounts. You have to drill in the account, whether it's in the iCloud, right? And I'm not talking to look on your phone and go to your iCloud settings. You need to go to a computer and log into your iCloud account or your Google account from a computer. And you need to go through the menus and look and see where it shows every device that is logged into your account. And you need to go one by one, click, 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 to log them all out, including your own devices. Log them all out for your iCloud, your Google, your WhatsApp, whatever accounts you have that may have sensitive information in it. change your passwords, and then you log back in with your phone, your iPad, your MacBook, the devices that you know 100% are yours. You're the only one that controls them. You've already changed the logins and the unlock codes for them. And now there's a new password on the account, and you've kicked every other device in the world out. And yeah, it's a pain. It's a little tedious to have to do that, but that's what you need to do. And then in each one of those accounts, your iCloud, your Google, whatever is important, you need to go further in the account, look in the menus, and you'll find what I'm talking about. You need to find, Apple calls them trusted devices, Google calls them something else, okay? Devices that are registered to receive MFA codes and security codes. Just because you kick the device out, see, it should logically tell Apple or Google, well, I kicked this device out. It shouldn't be a trusted device anymore. But their system doesn't work that way. Just because you logged out some random device that was logged into your iCloud, Apple still considers it a trusted device if it already was. So you need to go and delete those things as trusted devices so they can't get 2FA codes and log back in or try and change your password, etc. Okay. And while you're at that, you need to make sure that 2FA or MFA, two-factor authentication, is enabled for every single one of those accounts, and that you look carefully at the destination options for those MFA codes and make sure there's not a phone number or an email address there that you don't recognize and isn't yours that you control. Because we see that all the time too. You know, they say, oh, I changed my passwords. I did this, I did that, I did all these things. And the other party still keeps getting in. Well, that's because when we look, we see, well, what's this phone number here? They're like, oh, that's my ex-husband's phone number or my estranged husband's phone number. Like, well, it's listed as a 2FA device. So he can get a security code texted to that number to log back in. So all of those things are very, very important.
So that's why we send people to you, Nick, and while we're going through this, because it is complicated. And I think that people need to know that if they are having this difficulty, in all seriousness, your firm is there to deal with it. I can't tell you how many times I've sent people with their cell phones over to Nick's office or with their computers to Nick's office, or his people will come to you and deal with it. So it is actually really quite important. I'm going to bring up one more question to you, Nick, and then I'm going to come back to you afterwards, but I want to move on to Amy. But I do have a question because this comes up so many times, I can't tell you. So at least a few times a year, we get a case where somebody actually is able to read the, I guess it's IM messages that are coming through on the iPad, that is their children's iPad, from their spouse. It's got, more information than they could ever imagine, right? And it's just coming through and all of that. And I always worry about our clients having the same thing, that maybe their information is doing the same thing because of a family iCloud account. Can you tell us
So,
what a family iCloud
sure.
account is and how they go to
Yep.
deal with that and make sure that this isn't happening?
We see it all the time. It's so common. We call it iCloud bleed. And we've had cases, Lisa, with your office involving this. So the rule is very simple. Look, if you live in a household where everybody gets along, it's hunky dory, nobody's getting divorced, divorce is not, an issue or, a specter in the future, and you want to all be sharing iCloud accounts and everything, fine, so be it. Who am I to tell you otherwise? But the minute a divorce is on the horizon or there's problems or trouble, in the home that may lead to something like that, you have to isolate your own iCloud, Apple ID and iCloud account from everyone else in the household. And that includes the children, which means if your 9-year-old has their own iPad, whatever, own Apple device, they need to have an Apple ID on the device if you want to be able to, download games and things for them, etc. You cannot put your Apple ID in their device. which is what we see all the time. People do it innocently enough. Once you put your Apple ID in your 9-year-old's iPad, all it takes is to go on that iPad, click the iCloud settings, go to text messages and iMessages, click the two buttons on for iCloud, and within minutes, all of your messages are going to start syncing to that child's iPad. So the rule is very simple. One Apple ID per person. It doesn't cost anything to set one up for your kid. You just make up a Gmail, takes 5 minutes, and you use that Gmail as the Apple ID. The kid doesn't even have to use that email for any real purpose, other than, just to confirm the Apple ID, and that's it. But you can't use your Apple ID, which gives access to everything in your iCloud, on anybody else's device in the house. Not once, not ever.
So Nick, if you would, as I said, I'm going to come back to you, but if you would put your information, there is at least 2 people who want your information in the chat.
Oh, sure.
So if you could do that while I move on to Amy, and then I'm going to come back to you in a little bit. So Amy, we're talking about creating financial security and precautions. And as an estates and trust attorney, when people go through a divorce, what documents should they be thinking about in terms of updating, changing, revoking? What should they be thinking about?
So ideally, they think about this before there's a divorce filing, because you have a lot more flexibility pre-divorce filing than post. I'm not talking about being divorced. As soon as someone files for divorce, there are protective orders that you cannot start changing, moving account balances, changing beneficiaries, etc. So if this is in anticipation of divorce, but nothing's been filed, you might want to go in and change beneficiaries on accounts. You might want to change your will. You should probably think about doing a revocable trust if you have children, where you can put minors on an account. However, that will end up in 2 different courts. In New York, that's surrogate court and Supreme Court. So that's very problematic. But the thing that I don't know why people don't run and not walk, either pre-divorce or you're going through divorce, is number 1, healthcare proxy. I'm not sure why you'd want the person that you're getting divorced from. And it's a very easy document to put together. And I understand that people are consumed with their divorce and they're like, I'm going to focus on that and then I'll focus on my estate planning. But why you have this person you want to divorce from making life or death decisions for you potentially is, you can name anyone you want. Protective orders don't stop that. Name your mom, name your sister, name your best friend. Not that hard. And then the other one that you are welcome to change is a power of attorney for financial affairs. So you may have not done it or forgotten that you've done it. I mean, certainly anyone who's put together estate planning documents should take a good look at what they have in place and make sure that is what they want. So even if you are in the middle of a divorce, again, you could change your healthcare proxy, you could change your power of attorney, you can change like your will or your trust. You just can't yet change beneficiary designations, but you might as well have something, sitting there ready to go saying, these are the people I want to inherit.
And I'm just going to say, you can't go in, Amy, and change the beneficiaries to accounts, but you can actually create a new will. You just
Right,
can't
that's
go.
what I was saying. You could change a new will, a new trust. You can't then attach your accounts to them yet while you are going through a divorce. Pre-divorce, you can. Pre-divorce, you're welcome to do what you want. There are provisions under most state laws, if not all state laws, that if you, for example, die before a spouse, they're entitled to receive, in New York, it's a third. So there are things that won't change under operation of law, but you're welcome to take care of everything else. And that would be hugely important. And if you have documents, you'd want to be revoking your prior documents. Mm-hmm. So not just sitting there revoking them in the office. But if it's a power of attorney, you'd want to make sure that you submitted everything to your financial advisors, your bank accounts.
So let's talk about the power of attorney, because that is one that frequently I think people overlook. Tell us what a power of attorney is and what exactly the steps that they need to take to revoke the power of attorney.
So power of attorney is a document that says someone can handle your financial affairs on your behalf. And generally speaking, it's not limited to your incapacity. A general durable power of attorney, which is what most people sign during estate planning, they can, your spouse or whoever you named, it doesn't have to be a spouse, can simply go into the bank and say, hey, here's the power of attorney. They don't need to prove your incapacity. So if you have executed, which most people do execute those kind of documents during their estate planning, but you would certainly want to revoke it, name someone else, revoke it, submit it to financial institutions. And I think you would be wise to give this to your matrimonial attorney to pass it on to your, hopefully to be ex-spouse's counsel, so that if they go, oh, I didn't know, oh, we were going through a rough patch and I thought this was just, talking with attorneys to get us back in track, you're like, absolutely not. You had no business going into any bank, even though you had a power of attorney. You knew it was revoked. Your counsel was told, etc. Because I wouldn't strictly rely on your walking into whatever bank that they have every document listed on their screen.
But I do love, actually, and I'm going to say this, so normally we do send the powers of attorney revocations to the other attorney. And I do have my clients send it to their spouse as well. But I do love the fact that you should send it to the financial institutions. That is very, very important.
Right. Because even if they lose it, or they don't lose it, but they don't pay attention to it, I mean, they're going to have a certain amount of liability.
That's correct.
Right? They've received a revocation.
Exactly.
So if money has moved after that, you not only have your spouse to go after, but you have a financial institution that had a power of attorney. Someone went in and handled whatever transactions on your behalf that were clearly not authorized because you submitted it to them. If you don't submit it to them, they have a perfect defense. There's no way they knew that it was revoked.
And somebody said here, change your trusted contact on financial accounts. And I think this person is a financial advisor. This is requested on all investment accounts now, so be sure to change that info. So I appreciate whoever actually just said that. That was very helpful. Now, Amy, we've had many cases with revocable trust and irrevocable trust, as you know. We've had many of them together. So tell us the difference between an irrevocable trust and a revocable trust.
So a revocable trust, you can revoke. It's an alter ego. You can do anything you want. It operates like a will substitute. That's not really where we have a problem. Where we have a problem is irrevocable trust. And where Lisa and I have seen a number of cases where that it's usually the wife who's not paying attention. They're sitting at the attorney and their husband and the attorney says, this is for estate planning purposes. We're signing these documents. And they just go sign away. And what turned out is, hey, whatever, $5 million went to mom, and it's better with mom than it is with us because it won't be taxed for us. And it's like, guess what? That $5 million just walked away and you signed up on that. We see people who say, oh, it's better to move assets out of our name and into our kids' names. And then all of a sudden, there's no assets to talk about. They thought they were wealthy and they didn't realize that they had moved money away. So if you're doing that, don't tune out when you're sitting with your estate planning attorney, your accountant, your financial advisor, and go, ooh, my husband or my wife takes care of this. These people, if you're sitting with them, they represent you too. You ask questions and they have to answer them. And if you don't understand, please don't be embarrassed. Ask them they work for you, ask them to explain. You really need to know what is there and what you're giving away.
And, I'm going to say, Amy and I have had these cases. Some of them are actually very large cases where a lot of money has moved. And a judge can only do so much after that money has moved because you were part of it. And so, one judge once said, the fact that you did nothing is still doing something, right? So the fact that you just, you signed the documents and maybe you didn't read them, maybe you didn't ask any questions, maybe it was late at night, maybe you were busy with the kids, maybe, but these judges, they can only do so much, and very often money is moved out of the marital estate before the actual divorce is started, and it's done for divorce planning in many cases. And so when somebody says, let's go to a trust and estates attorney, and I think a big signal is you're in couples counseling. I see this all the time, and you're going to the trust and estates attorney. Like, okay, folks, like, it's time to think about whether that's a good idea. And it's okay to do something else in addition to what Amy said. It's okay to take the documents and say, you know what, I'm going to have them reviewed by a different trust and estates attorney that I actually have chosen, that I just want a second opinion, right? We do it with doctors, we do it with other things. I'm just going to get a second opinion. I'm not signing this right now.
But regardless, if that person has drafted documents for you, they represent you. I don't care if it's your spouse's best friend. When you ask questions, and you should be asking questions, and the number one question Lisa framed already is this revocable? Can this be changed? Right? That we can all understand yes or no to that question. Right? These are complicated documents, but there's some very, very simple questions. And if the answer is no, this cannot be changed, then you need to ask some follow-up questions, like what's it going to be funded with? Because you could sign something and it seems okay, and oh, it's just for a little teeny gift. But then the question is, could a larger gift be put in? Right? You sign something and someone's like, oh, it's just to make a small, like, annual exclusion gift, which these days is 19,000. It's just for those little gifts. But that doesn't mean you couldn't put $1 million in it or more.
And I think that that's really important. And somebody has asked here, why would anyone actually choose a revocable trust? So you want to answer that?
Well, that's just standard estate planning. It's like a will substitute, but doesn't have to go through court if properly used. So a revocable trust is probably, I'm going to say, in everyone's arsenal if they're doing estate planning. That would not raise my eyebrows at all, right? It's the irrevocable. I'm creating something that I cannot change, and that means you're putting something in it that you cannot get back.
So I love this question. I'm going to actually answer it. So my father-in-law passed away while we were in the middle of a divorce. Do I have rights to my husband's inheritance? So the answer is going to be no. Okay. The answer is really no. And even if it wasn't that, even if he had passed away before the divorce, if your husband kept those monies separate and apart from marital monies, and he was able to trace the monies and show that it came from his father, you would not be entitled to it under New York law.
So Lisa, let's take this a step further for matters we've also handled, which is, I know people don't always want to tell their parents, their personal business, but if your parents have wealth, you want to check in with your parents and probably say, hey, maybe you want to give assets to me in trust. Maybe you don't want to sit with a pile of funds outright. Maybe there's some protection in there. And you can easily speak to a trust and estates attorney. I could give anyone pointers on how to speak to their parents, even without telling them they're contemplating divorce. I could give them a whole series of tax reasons for them to do this. And so we would take care of that problem coming down the pike.
So Robin, you're up.
Perfect.
So Robin, okay, you've gone through a divorce. And I'm going to ask you first, what tips do you have for people who are either starting or in the middle of the divorce and they're ready to basically say, like, I've had enough, I just can't take it anymore. It's costing so much money. I don't think this will ever get through. I won't find any of the assets. I don't know. It's just not worth it. I'm just going to like just be done.
Yeah. Well, I think you bring up a couple of really good points, Lisa. One is that when you're in it, it does feel like it's a never-ending process. And it does take a long time. I've never, except for, divorces in fairy tale land, like every divorce takes many months, if not years. This is not going to be like, oh, it's January. I guess it's February now. I'd be surprised if you started a divorce action now and we're all done by the end of the year. I'm sure you've seen it happen, but like those are the rare exceptions. So you're in this for the long haul. This is a marathon, not a sprint. So in order to be ready for that, or if you're already in it, I think a couple of things are really important. One is you need to be strong. That means physically strong, mentally strong, financially strong. So, how do you do that? Well, first, you have to really take care of yourself. You have to make sure you're sleeping, you're eating, you're doing all of the basic stuff because that makes a difference. Second of all, you need to make sure that you're financially strong because I find that a lot of women go into this process not knowing what they have or don't have financially. And to just give a little bit of background on myself, I've worked in finance since graduating from college and even going through the divorce process. And I was the one that managed all the finances in my household. It still felt overwhelming and daunting to me. And this was not brand new. So, you need to work with a financial advisor. You need to talk to people, get advice, and really understand your finances because that's going to be a big key to sustaining yourself through this process and then moving out of this process. So that's really getting strong. I think the next part of it is really finding the right team. Now, that's obviously going to include a lawyer. It's probably going to include a financial person, and it'll probably include a therapist as well, because this is hard stuff and you need to have somebody that's really there with you through this process. So you have your professional team, but then I think it's also important that you have your own personal team as well. And that's going to be a really tight circle. This is not the time when you want the whole world knowing your business. That's not going to be good for you in your community. It's not going to be good for your kids, and it's not going to be good for your case. So, this is a time where you get kind of small in your social world and you find those two or three people, maybe it's a sibling, maybe it's a best friend, whatever it is, that those are your people and that's it. Your business is not for everybody else, and everybody else gets the party line of, yes, this is really hard. We're working through this. We're doing what's best for the children. We're trying to be amicable. That's the party line for everybody else. And then I think the third thing is you want to be strategic about this because divorce is all about the details, and your lawyer is going to be focused on the details, your financial advisor is going to be focused on the details, but the details add up. And if all you do is go through documents and respond to, one-line emails and get bogged down in the minutia, you're missing out on what you're really creating your life to look like afterwards. So this is where it's important that with this great team of people that you've assembled, the professional team and the personal team, you really try to figure out what is important to you, because what was important to you as a married person may look different than what will be important to you as a non-married person. Things like your children, things like your work, things like your family, things like your, hobbies and all of those things, you're going to carry most of those through into this next chapter of your life, but it will look different. You probably won't live in as expensive of a house. You probably won't drive as fancy of a car. But if those things are important to you and you can afford them, then let it be known so that those things come out on top and maybe other things don't. So that's kind of my high level. Whether you're starting out, because certainly in my case, I did not start out with all of those things figured out at the beginning. I kind of pieced it together as I went through it. But being on the other side of the process, I wish I would have had somebody telling me those things at the get-go, even though Lisa, you may have tried to tell me those things, but I maybe didn't listen.
Yeah, that could have been.
Mhm.
But in any case, Robin, I want to talk about the marital residence
Yeah.
because that is a huge issue for so many people. Whether or not it's important to remain in the marital residence, the pros and cons, and kind of if you're not going to remain in the marital residence, how do you pull it all together? So, can you give some
Yeah.
pointers here?
So I would say, aside from custody and schedules, the house is probably the most emotionally charged topic throughout the divorce. Usually, and again, Lisa can opine on this, but in many cases, I would imagine both people want to stay in the house. And there's a lot of memories there. There's a lot of, everybody's possessions are there. And that's really the center of the family life. And when I was going through my divorce, a lot of the peanut gallery would say to me, "Oh my gosh, you're the mother. You have to stay in the house with the children. That's just, what needs to happen." And I think in many, decades past, that was what might happen. I think it's different today. I think it needs to be a conversation, certainly about the children, because whether they should stay in the house or shouldn't stay in the house with one parent or the other parent, there's a lot of different ways to think about that. Maybe it's in a school district that they need to be in, and that's the most efficient option to stay in the house and have one of the parents stay. Maybe that's not important. But I think as you're thinking about it for yourself, you really need to think about the financial implications of it. And you probably went into this house with possibly two incomes, with possibly the a plan to be able to, pay down some of the debt over time. And all of a sudden, if you are now one person carrying this house, especially if there's a lot of equity that may have accumulated in it, and you might have to buy out the other spouse, it can be a huge financial burden. So to just speak a little bit about my situation, when we were going through our divorce, that was the case that I found myself in. The house had a lot of equity in it. It was an older house. And I, really, it was a decision that came out through many, many months in the process, but it didn't make sense for me financially and many other reasons as well to stay in the house. So that was a hard decision. It was a scary decision, but it really was the right decision. And I ended up working with a real estate agent who was phenomenal. And this was all during COVID when there were no rental properties to be found. But I moved into one rental and then a second rental. And then about a year and a half or so after my divorce was completed, I ended up buying my own home. And it's a house that is just right for me and my children. It's not too big, not too small, right location, right price. Had I stayed in the marital home, it would be a huge financial burden and it would, really change the course of the decisions that I've made since the divorce. So I think you really have to reimagine your life. What you knew before is not necessarily going to be the case post-divorce, and that's hard to do, but you don't want to be saddled with something that is going to do you more harm than good. And it's been really a breath of fresh air for me and my children to create new memories and set up a new house and have this as our own space. So, yes, there's a lot of good memories attached to the marital home, but, we have a lot of good memories that we've associated with our new home too.
Amy, I'm going to speak about the marital home with you. Actually, I'm going to do a circle back now in the other direction. And so, with respect to the marital home, there are expenses in the sale of the marital home that have to be dealt with. And if you could talk about some of those expenses, if you keep the marital home, what that looks like. So, for example, the capital gains, the deduction, all of those kinds of things. Can you talk to that issue?
Sure. Well, your basis in the home is going to be what you purchased it for if you end up selling it. If you sell it during your marriage while you have both names on it, there's a $250,000 deduction for each spouse. So that's, I'm an attorney, I can do this simple math. That's $500,000 that you're going to get in a deduction. If you're thinking you're selling the house, it's probably the time to do it while you have two names on it. It's probably a bad idea to go, hey, probably I'm going to move, but I'll put it in my name. Yeah, we have a lot of gain. I'm going to get this house, but I'm not going to factor into the fact that I'm selling it in like whatever 3 years when the kids get out. I only have a 250 exemption, and I have to pay all of these capital gains from whenever we purchased it and whatever the major capital improvements. So you really want to think about that when you're really wed to keeping the house, right? You're not wed to your spouse, but you're wed to keeping the house. So along the lines of what Robin was saying is, don't just fall into the fact that, hey, everybody wants to keep the house and if you're the mother and this is what I'm supposed to do, if that's the case, great, that's the case. But give some thought to what the tax consequences are down the line when you're selling it, especially if it's expensive for you to keep. You know, if you're saying, I'm going to keep it until the kids get out of school, and that's in, again, 3 years or however many years, maybe negotiate something else. I mean, we have clients who they might keep both names on it and say, hey, the mom's going to stay in the house. We'll agree to sell it after, 4 years when the youngest child graduates, and here's what happens, etc. And even in your settlement agreement, you can come up with, you have to show in like whatever your will or your trust, if you predecease, you're going to say it goes to the other spouse or whatever it might be. There are ways of taking care of that.
So that goes to my next question in terms of other money. So besides the capital gains, if you're keeping the house, you've got the broker's fee if you sell it in those next few years, right?
Yes. So
And
whoever's leaving the house is probably getting a sweetheart deal, right? You get it valued, and your house is worth $1 million, and you're giving them $500,000. But by the way, when you sell it, you're paying the capital gains tax, you're paying broker's fees, you probably have to doll it up a little bit. You're not doing the same sort of due diligence as when someone comes in and says, hey, the boiler's been here for, 20 years. I'm not going to buy this unless you give me this credit, and this, this sink doesn't work and that doesn't work. You're not doing that same kind of valuation in a divorce. So be really careful. There are ways to, if you're buying your house, there are ways of going, it's not the value it is.
The other
and
thing is there's, risk associated with that, because as soon as you take this transaction out of today and move it into the future, you took something that was a joint risk and put it all on your shoulders. And your life may change post divorce, and that house, that may have served your needs perfectly during your married and family life may no longer. So, I think you really need to just think about all those things. And again, this goes to that reimagining idea. These are hard concepts to think about, and it's against what you've probably thought of for many, many, many years of your life. But that's why you have experts like Lisa and Amy and others to kind of kick the tires on this a little bit and help you stretch your thoughts and say, could I consider this? What are the pros, the cons, the risks, etc.?
It's especially because if your spouse is usually the one who deals with this, then you need to put on a different thinking cap. And if the roof falls in, you better have, a good amount of money to go fix that.
exactly.
right? So there are things that can come up. It's not just doing an analysis of can I pay the real estate taxes, etc. It's if there's a problem, what is that? And actually, if not just looking online, like, hey, if I sold my house, it would be X amount of money, right?
Exactly.
If you were buying a house, you wouldn't go online and go, oh, that's the price. I don't need to do an inspection. I don't need to look at, if everything's working here, I just buy it at what I see online. Like, spend the extra money, go get a certified appraisal. If you're the one who's, buying the house, then go through and go, this doesn't work and this doesn't work and this is a problem, so that you're getting the real value on your house.
Nick, all right, I'm going to move into a couple of different questions. So there's a lot of people who do recordings during litigation, okay, in their divorce litigation. They record each other. They record all these different recordings, right? So talk to me about a few.
Oh, I think Nick needs to be unmuted.
Nick needs to be. Are you muted, Nick? I think you're muted.
Thank you.
Okay. Okay. So in terms of these recordings that people do, there's many issues with them. What should people think about in terms of recording? So I'm thinking, just so you know, like about two-party consent, one-party consent, all of those kinds of issues. I'm thinking about where you store them, how you store them if you want to use them for litigation. And then I'm going to move, just to tell you where I'm going next. I want to understand a little bit about cryptocurrency. We're going to get like a little teaser about cryptocurrency.
We're going all over the map tonight.
We are.
Sure. So audio recordings, video recordings, obviously are a common type of evidence in family law proceedings, whether it's custody proceedings, divorce proceedings, what have you. And of course, they've become ubiquitous now because everybody takes them with their phone, right? Their iPhone, their Android. So first things first, your first question about one party, two party, etc. So that everyone who's listening is clear. It is perfectly legal to record a conversation that you are a party to in New York without telling the other person, without asking them, without telling them you're recording it. It's even legal if the other person says, I don't consent to you recording me. You better not be recording me. And you say, I'm not recording you. You just lied, but that's not illegal. And you're recording them, right? That recording is legal and should be admissible in court if it's authentic and it's otherwise relevant. The issue now becomes, what about if I'm having a conversation with my spouse who we're having trouble and I'm recording it on my iPhone. And now I leave my iPhone on the table, right? Turned upside down so no one can see the screen of it. They don't realize it's recording. And I walk into the other room, or I walk 2 rooms away for 10 minutes. And that person is still in the kitchen conversing with their brother, their mother, or one of the children, right? An adult child, whatever. That's not okay anymore because now you are no longer a party to the conversation or present thereat, which is what the statute says, right? You've got to be like in the room and or a party to the conversation that's happening for it to be legal because New York, that's the law. And if you're not a party to the conversation or present while in the room while the other person's speaking and being recorded, that's not just a slap on the wrist kind of thing. That's a Class E felony in New York. It's called eavesdropping. Okay, very serious. And there's in the New York civil practice law and rules, I think it's 4506, says if you made such a recording, it's not admissible as evidence in any proceeding, regardless of whether you get arrested or prosecuted or anything else. All right. So there's no reason to do that ever. It's illegal and it's not going to be admissible in court. So if you're going to make these recordings and they contain audio, whether it's just audio or it's a video with audio, you need to be a party to that conversation or physically present in the room while the speaking is going on between the other people. All right. Once that recording is made, and assuming it's legal the way you made it, yes, you need, and it's important and going to be important to your case. You have to think about, okay, how do I now preserve and protect this? Well, if you made it on your iPhone or your Android and you're backing that up to iCloud or Google, that's some measure of backing up and protection. There's two schools of thought here. And the first one is this. If you're already in the divorce, right, or the litigation, custody, divorce, the litigation's already going on, you're already working with your lawyer, you're in court, whatever, the proceedings are underway, and you have this recording that gets made, and okay, now I have the recording of XYZ happening, and I know this is going to be important. This is bombshell stuff. You get a copy to your lawyer right away, okay? And the lawyers on this call know this, the lawyer sends a copy to the other side with something called a notice to admit and says, here's this recording. I'm not asking you to admit that it's relevant. I'm not asking you to admit anything else. I'm just asking you to admit that this is authentic. It's not fabricated. It's not manipulated. Nobody messed around and inserted words that your client didn't say, what have you. Mm-hmm. And maybe the other side listens to it, plays it for their client, and they say, yeah, that's legit. That's what happened. And they admit it. If that happens, you don't need me or anybody like me, right? So I just shot myself in the foot, right? No, seriously, that's the simplest thing to do. And if the circumstances, and the timing of the case permits, it's the way to go. If the other side refuses and says, no, we're not admitting this, we deny it, whatever, and you have to call someone like me to come and authenticate that, which means we come and extract a copy of it from whatever device you made it on. We forensically examine it. Then we have to give an affidavit or come to court and testify live to say, we collected and preserved this. We examined it. It was made on this device, on this time, on this date, and our examination shows that it has not been altered or manipulated or fabricated or messed with in any way. It's authentic, right? If we have to come and do that after your lawyer sent it to the other side with a notice to admit, and they refuse to admit it, and the judge says, no, I believe this expert, this thing is authentic, you can ask the court, your lawyer can ask the court for the other side to reimburse you for those expert fees, and they know that. So usually they'll admit it unless they have a really good reason not to. Now, if the circumstances, the litigation didn't start yet, for whatever reason, you and your attorney make a strategic decision, we don't want to share this with the other side right now, maybe we're not required to under the discovery that's going on, whatever the case may be, we're not giving this to them until we have to. And that could be next month, 6 months from now, we don't know, whatever. And this thing's really important. You shouldn't trust that, well, it's on my device and it's probably backed up in my iCloud. Not a good way to go. Under those circumstances, you tell your lawyer or you contact someone like us, and we take your device, we make a forensic extraction from your device with all the audio and video and whatever else you recorded, etc. And now we have it forensically preserved. We don't have to do anything else with it at that point, but we've preserved it. So if your iPhone gets lost or stolen and your iCloud got hacked and deleted, or some other crazy thing happened, etc., we have the evidence and it's not going anywhere. So when and if you need us to, we can produce it to your lawyer and, come and testify to its authenticity.
All right, so we're going to do a quick crypto because we don't have that much time left. Tell
Changing
us,
hats.
tell us about tracking cryptocurrency. I know you do this, right?
We do.
Okay,
do.
so tell us what you do so that people
Sure.
who are trying to track cryptocurrency know to come to you, Nick.
Okay. So, let me be as concise as I can here. In this context, in a matrimonial context, right? What happens? One spouse, the divorce is happening, and one spouse says, "I know the other party has cryptocurrency," but they're not admitting to it, and they didn't put it on their statement of net worth. But I know they invested in cryptocurrency. I heard them talking about it, et cetera, et cetera. I know about it. We need to get involved, and we need to talk to that client about trying to, first of all, if the client is still in the house, they're still cohabitating, living together, just like there are important financial documents that the lawyers and the accountants say, listen, you got to search the house and look for bank statements, and you got to look for this and this. There's a whole list of things that we give and show pictures of to the client, say, you need to go look for, tear the house apart looking for this. And we show them what to look for, things that are evidence of cryptocurrency transactions and activity that will, among other things, give us a starting place to do the forensic tracing on what are called the blockchains, right? To track that cryptocurrency, see where it is, see where it's gone, see how much of it there is. Okay. We also get involved with helping the attorneys subpoena the cryptocurrency brokerages and exchanges, the Coinbases, the Krakens. A lot of people know Coinbase, Kraken, Robinhood, and maybe one or two others. Most people might be shocked to know there are more than 60 full service cryptocurrency brokerages and exchanges that operate right here in the US that will respond to a subpoena you send them if it's properly, formatted, etc., for information about, does this person have an account with you, and we need a full transaction history from that account. Assuming we get that, that's not the whole story, because we have cases where we got the person's Coinbase statement. We didn't have to subpoena it. It was the one thing that was actually produced in discovery. But now we have to take that Coinbase statement, and the party produced it and said, yeah, here's my Coinbase statement. And there's $342 in it. Right. But there used to be a lot of crypto. They're not as easy to read as bank statements. They're complicated. You have to know how to read them and figure out how much crypto is in there at what point in time, how much it was. They don't give running balances the way banks do. That's a really big thing someone should talk to these institutions about. But anyway, we get that statement. One of the main things we're looking for is outbound cryptocurrency transfers. In other words, somebody sent 12 Bitcoin out from their Coinbase account to somewhere. Where? Well, did they send it from their Coinbase account to their Kraken account? Because they didn't disclose any Kraken account. Usually what we see is it went to a private cryptocurrency wallet, but we can identify that wallet, and we can see what other transactions that wallet has been involved in, and we can usually determine to a reasonable degree of professional certainty, which is the legal standard, that this wallet over here that received 12 Bitcoin from this person's Coinbase account is owned and controlled by this same person. And then you can have the court do what they have to do.
Love that. All right, we're gonna next year at this time, Nick, we're gonna do a big crypto currency, but I can tell you,
You're
I'm
on.
already having you come to my office to do an in-house seminar for all of us.
Whatever
Because
you want.
this is an area that is so interesting to me. I want to thank all of you. Amy, you're amazing. You're an amazing trusted estates attorney. And I go to you, as you know, for all of that. And you have been a huge asset to our firm. And Nick, thank you so much for bringing all your knowledge. And we won that motion because of you, and I appreciate that. And Robin, you know, I've known you for years, and you are amazing. And to all the savvy ladies who are on here, and to the savvy men, all our male allies also, who are also on here, we hope that you got as much out of it as possible. I know that many of you had questions which went unanswered, and I would say there, Amy, you might want to put contact information. I'm sure there's a way to do consultations, etc. With everybody who's
I
on
also
here.
think on the invite, right? Doesn't everyone have
Yes,
our bios on the invite? So
yes.
just go to the invite and you can look all of us up.
And so,
I put an email in the chat. That's the info at the NGH group, which is my firm. If anybody has any questions, just when you email, please just say, you know, you were it from the Savvy Lady panel, et cetera, et cetera. We'll answer your questions whether you're hiring us or not, and et
very
cetera,
kind.
if you just need some advice.
That's very kind. And panel 4 will be, Judy, what's the date? I don't want to
Panel
get this.
4 is February 18th,
Okay. And we're going to,
and
go ahead.
we're discussing getting ready for your career pathways.
Exactly. And we will have a vocational analyst who is coming, who is an expert in the field, who interviews people, comes up with what their income could be, even if they're not working. If their a salary is too low, they actually do an analysis of that based upon education. And we also have some other great career experts coming on. I see some of them right here. I think Carol's here
Carol
actually
from
tonight.
SheQuip, yep.
Yep. And so we're very excited for that panel because that's a brand new panel for us. So we will see you guys in, I guess, like 2 weeks, right, Judy?
Yep.
2 weeks. So everybody have a great rest of the week, and thank you all. And thank you, Nick and Amy and Robin.
Pleasure to be here.
Thank you.
You guys,
Have a
bye-bye.
great night.
Thank you. Good night, everybody.